Welcome to this video series on the Making International in Korea. We will begin in this week of videos with a description and explanation of the core principles and practices of international law and discuss the primary sources of international law in Korea, like the development of international in Korea and Japanese colonialism and Korean war and inter-Korean relations and peaceful settlements of international dispute. The development of international in Korea is traced back to the late 19th century, when Korea was confronted with public international law introduced by the Western imperial states and further influenced by the Japanese colonialization from 1910 to 1945 and U.S. military the administration in the southern half of the Korea from 1945 to 1948. The Republic of Korea was formally established in 1948 with the adoption of its first constitution. The history and legacy of Korea play an important role in shaping the contour of Korea's legal system, as well as the Korea's international relations. The legal system of Korea particularly underwent drastic changes during Japanese colonial rule, as the Japanese government tried to apply their civil law system based on the continental European legal system to Korea. Such legal changes imposed under colonial rule created challenges because Korea was faced with a conflict between its deep-rooted Confucian traditions and the newly incorporated European-oriented legal principles. After Korea gained its independence in 1948, the issue of reconciling the Confucianism and colonialism in Korean law was additionally intertwined with the noble principle of the constitutionalism that come about due to the growing influence of the Anglo-American legal system in Korea. Korea's approach to international law is explained through the interpretation of its constitution, which stipulates in relevant parts that the treaties duly concluded and promulgated under the Constitution and the generally recognized rules of international law shall have the same effect as the domestic laws of the Republic of Korea. In accordance with this provision, international law has been generally accepted as Korean domestic law and incorporated into Korea's domestic legal system. While the Constitution explicitly set forth that treaties duly concluded are accorded with the same status as the domestic law of Korea, there is no specific mention of customary international law. The term generally recognized rules of international law is largely interpreted to mean customary international law. Regarding the status of international law in Korea's domestic legal system, the prevailing view is that both treaties and customary international law stand equal with domestic legislations. While the treaties ratified with the consent of the National Assembly are deemed to have a status equal to statute passed by the National Assembly, those simplified treaties without legislative consent are deemed to enjoy the same status as decrees issued by the President and all the various ministries or enforcement decrees under the statutes. The tumultuous experience of the Korean nation in the 20th century within the context of the international relations in Northeast Asia has had a significant impact on Korea's attitude toward and a practice of the public international law. Korea has many issues to be settled under international law. Such issues include, but not limited to, territorial disputes with neighboring states, issues of transitional justice, and issues regarding the limitation of maritime boundaries and fisheries. As to adjudication as a means of dispute settlement, Korea has not recognized the compulsory jurisdiction of the International Court of Justice. However, Korea has accepted the compulsory jurisdiction of the ICJ for disputes arising out of the interpretation or application of the optional protocol to the Vienna Convention on Diplomatic Relations concerning the compulsory settlement of dispute, as well as the optional protocol to the Vienna Convention on Consular Relations concerning the compulsory settlement of dispute. Korea, as a party to the UN Convention on the Law of the Sea, UNCLOS, submitted a declaration under UNCLOS Article 298 in 2006. Korea generally remained inactive in employing international adjudication as a means of dispute settlement. Moreover, Korea have not employed non-judicial means of dispute settlement, such as inquiry, mediation, or conciliation. The only bilateral agreement concluded for the very purpose of dispute settlement is the exchange of notes concerning the settlement dispute concluded between Korea and Japan in 1965. One of the possible explanations for Korea's rather confined choice for dispute settlement is that most issues at stake are delicately related to territorial matters, which can never be easily left for third-party decision. As a full-fledged member of international community, Korea has been actively involved in a number of activities at international organizations and conferences. Korea particularly devoted to multilateral diplomacy at the United Nations and gradually pursued bilateral diplomacy even in the multilateral forums such as the G20 summit. Moreover, Korea utilized its UN diplomacy to extend the scope of its global participation in major global agendas, including but not limited to human rights, environment, terrorism, and poverty. The hosting of the major international forums such as the G20 Seoul Summit and 2012 Nuclear Security Summit and the fourth high-level forum on aid and effectiveness in 2011 showed that Korea's national capacity to serve not only as a global agenda setter, but more importantly, as a bridge builder between developed and development countries. Korea's engagement with the international community extends to humanitarian and disaster relief efforts through its participation in the UN peacekeeping missions. Thank you very much.